we proceed?
Yes, I'm ready.
Okay. Respected chief guests, dignitaries, teachers, and all the students, a very good evening to one and all. I, Soumya Sharma, extend a very warm welcome to all of you on behalf of Deccan Education Society's Sri Navalmal Firodia Law College. Today, we come to the fourth day of the 5-day alumni lecture series, Krutadnyata, conducted by the seminar and the alumni department. As budding lawyers and legal professionals, our core values, mannerisms, and legal ethics always play a pivotal role and will always be of paramount importance in all that we do. Hence today's lecture would focus on the importance of etiquette and courtroom mannerisms. Today, we are truly grateful and honored to have with us our esteemed alumnus, Advocate Anurag Mishra, sir, as our guest speaker. I welcome you, sir, and it is indeed a privilege to have been given the opportunity to host you. I would now introduce our esteemed guest for the evening. Sir was an avid mooter and he has represented our college in various national and international moot court competitions. Sir has also represented our college at university level in football and in basketball. Sir was awarded rank 1 in the convocation held by our college. Sir is currently an independent legal practitioner specializing in arbitration proceeding, traditional litigation, and civil matters. Sir has appeared before all courts and tribunals in Pune and in Mumbai. In the midst of COVID-19 pandemic, Sir has taken a noble initiative to offer free legal aid in the attempt to redress the grievances of people affected by any malpractice during their COVID treatment. Sir, I once again welcome you on behalf of DES Sri Navalmal Firodia Law College and request you to kindly proceed with your lecture.
Thank you, Soumya. With everyone's permission, I would like to thank the management showing trust day in, day out, years after years in me to be the person to give guidance. I'll not use the word able for myself, but then at least what I can share with my experiences as a student, as a professional now, and within 7 years of my practice now, the experiences that I have gathered, it's always good to share it with my friends who will soon be brother councils and sister councils at the bar. So I thank the management for showing that trust in me. Secondly, I would also like to thank the professors and the faculty in charge, also the team which is putting efforts and putting together and making use of the technology, because we are aware as lawyers, as students and professionals in the field of law, of practice and education both, that technology is the way forward for us. So probably for the best, we are putting in effort, and team has put a brilliant effort to arrange a seminar, which will probably will be shared with all the students. I can see a lot of students have joined. So yes, thankful to everyone to arrange this so that we can discuss a very important subject, which like the presenter opened and said, that goes to the root of your practice as an advocate and also as a mooter for that matter in your law school. So it is a very important subject, etiquette and court mannerism. Having said that, before I jump onto the topic and we go into the technicalities of mooting or the behavioral aspect of presenter as a mooter or as a lawyer in the higher courts or district court, I think we should also discuss the subject or the title of this entire seminar series. That definitely, once we go through it in a couple of lines, will make it clear that what the entire concept of Krutadnyata in Marathi or Kritagyata, those who understand English, means. The entire essence of that word goes around to say abhari in Hindi, or if you are supposed to say in English, it's grateful, being grateful for something. So far as I am concerned, I am grateful to the institution for inviting me back and giving me this opportunity to share my experiences. And as a lawyer, as a traditional litigation pattern, if I may say so, this is the word that forms the spine of your entire practice or your presentation or your communication with the court. And that is why you have to keep in the hindsight this particular word, Krutadnyata or gratefulness. And that is where, when you have that in your background, every sentence that you speak should drop an emotion that you're grateful about something. Or in that matter, we use the word oblige. We'll go to the details of what those particular words mean and why they are used in a particular way. So I may suggest that these are not only rules of practice, these are not mathematical formulas of sorts that need to be by hearted. This is a practice or something that needs to be inculcated by way of practice, by way of acceptance how the particular system works, by acknowledging the challenges the system has, by acknowledging various differences of communication that we have. Once you acknowledge all these situations, you accept this, deeper study goes into this, then you come out to be a better presenter, because that comes out for you to understand the queries better, to prepare for your arguments better, and more so about this, it prepares you to understand the other person better. This brings me to the word communication. Communication is what we are going to discuss today. Etiquettes and mannerism are just branches of the broader word, if I may say so, of communication. We are going to, as lawyers, facts and laws, these need to be communicated. These need to be communicated in a particular fashion to meet the best requirement of your case. So communication is the most important thing, or a focus criteria which goes beyond only research and typing or preparing briefs. Yes, typing and preparing briefs, you must have gone through other lecture series where preparation of moot court or preparation of your brief memorial is concerned. It is the same. Obviously, it is one of the most important things because that is where your research skills are displayed. But then eventually, as a lawyer, as an advocate, as a counsel, as an officer of the court, it's very important that what has been typed is equally communicated to the court. If only memorial could suffice, then it would necessarily be over research competition only. A moot court competition or advocacy travels a little beyond research and also focuses on communicating your case to the court or to the judges across the bar, and then obtaining a favorable order or obtaining the relief that your client expects from you, or the problem or the compromise expects from you to argue. And that is how communication is what we are going to discuss today. And it is going to be a very general discussion because there is nothing technical about it. This is one of the things. Etiquettes and court mannerisms, if I may say, are some things that come by doing it regularly, by being a part of it. So this is not something that we can note down in a notebook. Even today, a lot of incidences, a lot of experiences in our lives as advocates keep teaching us various aspects of these etiquettes and mannerisms. Some things that we might say, the judge perceives in a different way. And then any anxiety that we express to the court is not perceived that well by the court. So this keeps teaching us as to how important developing etiquettes and court mannerism is. So this brings me to a word which we call vigilance. I would always like to tell you there has to be constant vigilance. This is the part that I'm going to discuss now is the preparatory part of coming to a conclusion that why court mannerisms and etiquettes are important. So first part of it, like I said, I explained that law or argument or presentation of a case involves communication to the court of the facts of the case and the prevailing law combined together to assist the court to come to a conclusion in a proper fashion that this is what the ruling has to follow it. And hence, to understand this entire exercise, one thing that has to be kept in mind is vigilance. You have to be very vigilant of the things that are happening around you, not just in the courtroom, in the society around you, because cases do not drop out of heaven. They are not a particular fact which is set from heaven and they are peculiar to everything else. It is something that is happening around you. Whether there is a problem with someone's arrest, there is someone's problem with unemployment, not proper discharge of public functions, the government is responsible, anyone is responsible. So these are facts in and around you. And once you are vigilant about this fact or things that are happening around you, it always helps you as a lawyer, as a mooter, in fact. If we talk about mooting as a skill, being aware of your surroundings, being aware of the practical aspect of how a particular litigant who comes to court perceives his problem or what his real life problems are. It helps you understand better how to build a particular case. And this also helps your communication to the court. So when it is said, seeing through the brief is a phrase that we use, that you have to somewhere travel beyond the law, travel beyond the fact that is present before you, and be able to communicate to the court in a fashion the actual grievance. Because we have to accept that it is the judges who are sitting across the bar are humans too. It's a human mind, it's a brain, it has emotions. So that is why importance of this lecture, that what are the etiquettes, what are the mannerisms that we follow, how we build ourselves to come out to be a person who is genuine, who understands the cause he's appearing for. Because that brings me to the third. First was communication, second is vigilance that we have to have all around. Thirdly, we go ahead and we build our case. There is a skill, or we call about how a person responds to a particular situation. There are a lot of people who study psychologies. I'll come to those examples. I will also break a, a little bit of myth that we are going around, that traditional practice is following something which is a sheep chaos, that people are not just understanding the fact, but just saying that it was colonial. That is why we should not follow it. But there is a science behind it, why a particular thing is done in a particular fashion. That we'll discuss today. And that is how etiquettes and court mannerism in litigation, that as a mooter or as an advocate, it's going to remain the same throughout your career as a mooter and further as a lawyer also. So that is how important it is. So far as moot court preparation is concerned, I think lectures have been, I have seen the schedule, orientation of preparation of memorials that has already been done. If there are first year students, I think they must have gone through orientation lectures. People who have mooted probably in the internal mooting grounds or anywhere in competitions are aware what is the preparation of memorial, how a memorial is built. Secondly, when it comes to presentation, why it is important again, I'd like to share a couple of experiences that I have gone through. Uh, from this, it will teach you that how we learn from our experiences, that what are the etiquettes or the mannerisms that we need to follow. Uh, I was appearing in a court. It was not my case. There was a brother counsel who was arguing a particular case, and it happens to believe that there was a voluminous brief that he was supposed to argue. This is an example that the seniors, mentors keep giving you. So this is one of those experiences. So this gentleman expresses to the court that the matter is too complicated for the court to understand. Now, this is the blunt statement that he has put. There is no head and tail to the statement. There is no anxiety that he has expressed to the court. The first statement he comes up with is that, my lady, this is a very complicated brief for the court to understand. Now, the court got very anxious, and let me tell you, not in a very pleasant way. Why? Because his communication was not right. What this gentleman wanted to say is that because of the volume of the brief, it would be very difficult for the counsel to explain the complexity of the matter at this stage. Probably he was seeking an adjournment, probably he was seeking some time to prepare it better. But then the first statement came out in such a way that the judge completely blocked. And if that day he wanted some urgent relief, trust me, it could have gone against him. I wouldn't say that the judges are totally ridden by their discretion. They would have gone in the matter. They would have got into the merits of the matter. But then the tone that you set while you open your argument is what follows, and that is how the relief that is granted to you comes to an end, whether it is going to be favorable or not. It's not that 100% it's based on your etiquettes and mannerism. Obviously, 90% of it is the merit of the matter. But then to make the court understand, or make the court understand your anxiety and develop an intention to rule in your favor, these etiquettes and court mannerisms are the tools or the devices that you need to use, tagged along with good language, to communicate to the court that this is my case. So that is one example. If I give you a personal example, I was in the year 2018 arguing a writ in a big case of staying a tender of the Maharashtra government of road development by the PWD department. And in that writ, I was appearing before the Chief Justice of Bombay High Court, then Chief Justice of the Bombay High Court. His bench was leading the matter. And on that day, on the second day, I got very anxious because my tenders were opening in a couple of days. There was anxiety with the client, what would happen, whether they will lose the tender, XYZ. Then that anxiety got to me. And unfortunately, while the court was presenting a very technical query, which required being addressed at that very moment, I overspoke the court. And the court blasted at me. And I got a handful of gestures from the court, which were not pleasant, of course, as a lawyer. But then I realized it with immediate effect, and I apologized to the court. And the court conceded that yes, you have to control the anxiety sometimes. The client's call cannot override your etiquettes and court mannerisms. So yes, we of late also learn in our practice that there are some things where you have to lay the boundary, where you have to follow the etiquette, where you have to follow a particular behavior in the court. You just cannot debate. So that is one thing that I learned from that case. And we have had multiple experiences like this, which in our practice life also teach us that what communication and etiquette matter. Probably that could be the difference between a good lawyer or a great influencing lawyer. This could be a big difference if we really focus on the techniques of how to persuade a court. Now, coming back to your moot court, having shared that, coming back to your moot court, there are certain phrases, there are certain way of arguing, like arguments being done in third person, addressing a court in a particular way, where we have to understand that there are set principles to a moot court competition. I may not speak a lot about it because nowadays with technology, uh, everything is available. All moot courts are recorded. The final rounds are available. The best and best mooters in the country, they are available. The videos online on YouTube. You can definitely make sure that you go through a lot of videos if there's an upcoming competition or you want to develop as a mooter. There are a lot of lectures that are available from eminent lawyers who also express their concerns of how a person should behave while arguing or how he should express himself in courts. I very distinctly remember on this point, uh, Mr. Harish Salve has also mentioned the importance of etiquettes and court mannerisms. Now, he has a very notable thing that he said in one of his lectures. Now, he talks about hand gestures, something as small as hand gestures. So when we are arguing in a court of law, mostly in the higher courts, so the Bombay High Court or the Supreme Court or any high court in the state, it's always suggested or recommended by the seniors that we do not use a lot of hand gestures. So when you're on the dais, it's always expected from you that your hand gestures do not move above your chest or shoulder level. So which is not welcome. If you look back on it, if you put a better study into why this is done, then there's a certain type of a science behind the science of body language. How a particular person presents his case, how he stands, what a position in his standing means, how his hand gestures can communicate in a particular fashion are studied sciences. So that is why there is a recommendation that some gestures which may go beyond your chest line or the shoulder line while argument may not be welcoming to the person who's listening to it. So there is a science behind, and hence the recommendation comes that a lot of hand gestures are not welcomed by the court. In higher courts, definitely, you're supposed to be calm and composed in a gentle fashion. You're supposed to hold your diet and not make a lot of hand gestures. Similarly, it comes with expression. We are not. We may vary our tones. Definitely, we can vary our tones and we can exaggerate. Sometimes we can invite rhetorics not being expressed. Of course, you can invite rhetorics, and yes, as you get comfortable by knowing the court, how it uh, interacts with you, you can obviously use all those devices. But then again, body language, there's no substitute to it. You cannot let your facial expressions or your body language express more than you want to. So if your anxiety, what you need to express to the court is set to a particular limit, make sure that your body, your hand gestures, your facial expressions do not speak otherwise, or they do not communicate in a fashion which is detrimental to your own case. So you have to very well control it. Now, what practice we can have out of it is that you can argue, record yourself, listen to yourself, whether you sound convincing or where while reading a particular section or reading a particular argument or presenting a particular argument, where you need to apply a bit of pressure, whether that pressure comes as arrogant, whether it comes as rude or it comes as mellow, or it is not coming out the way you want to communicate to the court, all these things can be worked out. So one exercise that I recommend is to record your arguments in your probably your cell phones. Uh, there is another technique to argue before a mirror, that is also there, where you can see yourself argue, and you can address yourself whether this hand gesture is necessary or it is unnecessary, whether we can stop it. So yes, your body language plays a huge role. This is something you cannot speak out, but then it speaks on its own. So when it comes to etiquette and when it comes to body language, definitely hand movements are not welcome. Uh, at least definitely not beyond your chest line, and definitely not beyond your shoulder line. You have to probably hold crossed hands on the dais, or holding the dais in a polite manner, slightly leaning towards the dais. These are the positions that are very necessary while arguing. The science behind it would be the science of body language or what it interprets. You must have heard a lot of hue and cry a couple of years. This is my personal opinion. About a couple of years before, where entire there was entire group of lawyers who suggested that why would we stand and argue? We are following a colonial system. Why cannot lawyers sit down and argue? Why do we need to show that type of a deference? Because if they are understood to be correct, then I don't think the entire purpose of this lecture is defeated. Now, the way I see it is that if you understand the science of body language, it is always recommended that a person who wants to persuade a particular person should always be in a standing position of a person who is in a seated position. So if we see a particular construction of the court, why is the court held at a particular position? It is elevated from where you are standing. So this is a subtle sign where a person who expects himself to persuade the judge, if he is standing, the chances or the effect that it has on the mind of the judge is better towards being persuaded, but not towards aggression, or not as an equal. And we have to understand that fact that in the court of law, it is the judge who is going to define it. The fate of your case is going to be defined by the judge. He is the master of his court. Yes, I understand that, and I'm also of the belief that judgment should not be based on the discretion of the court. And our law system gives very little scope for the court to be only discretionary. We are guided by law. So in such situations, such persuasion techniques are very important, and that is the reason that it was built in a particular way. If we take another example, you'll always see professors stand and teach you. You are young, you are sitting down, but the professor is standing on the dais using the blackboard and teaching you. What is the reason to do so? Why a particular system of classroom was built in a fashion where the professor or the teacher has to stand and he has to deliver? Why do you see that the eminent leaders in the world, that stands are built for them? They stand and deliver their lectures or their speeches or whatever. So there's a reason. So how a human perceives or gets convinced sometimes uh, also is affected by who is the person and what body language he uses. So that is why standing and delivering your argument or your submissions in the court was followed and taken into the. This is my understanding of the whole bit and my analogy when I draw uh, within the teaching or giving lectures or speeches. That person who is delivering or whose job is to persuade the audience you will always find them standing and delivering their lecture, and that is how a particular pattern is followed. And that is why even in the law field we find ourselves behind the dais standing, and the judges being comfortable, if I can put it in that word, judges being comfortable in their seats. But that is how the system works, and it is better for you to persuade a judge who is sitting when you are trying to make an aggressive argument, though in a submissive way. You making an aggressive argument standing, because the chances of the judge believing it are more. And I can leave you with that example, and you can research on your own. You will understand that how this particular technique came to be developed. This is a subtle science which was taught, and it was developed in a particular fashion. Now, moving on, when we appear before the court, so I'll go to the technical aspects of it. I'll wrap that technical aspects, and then we can leave some room for interaction also. Uh, so one of the recommendations that I would like to make is that whenever you're submitting, you should speak slowly. You should be slowly and carefully is what I would suggest. That be careful of what you say, because as a lawyer, you need to understand the responsibility. As an officer of the court, there's a huge responsibility that you're burdened with. In your license to practice law, there's a big responsibility that is put on your shoulders. You are called the officer of the court. You are called a learned person in the society. So that is why every submission that you make should not be hostile to common sense. It should not be hostile to the provisions of law. So you have to be very careful of every submission that you make. And that is the reason I expect or I recommend vigilance that is constant in your everyday life. You have to perceive the fact how things are happening around you, whether it is in your society, whether it is in your group. When you perceive these things, that is how you develop a particular type of vigilance. And that is how a density in a speaker is created for him to be careful before the court of law. When you are dense with the material, with dense with experiences, dense with your constant vigilance, that is when you will understand that every word that comes out before the court of law will always be carefully put and articulated in a manner. It is through this vigilance, it is through this reading. When it comes to academics and preparation of your case, then definitely your brief and your case laws and your bare acts, those are the things that you're going to be aware of. But then that is not enough to address the court, because the court that is standing is human, is going to expect the practical aspect of it as well. So be very careful, be very calm and composed, keeping obviously keeping track of the time. In competitions, we are granted a particular limit of time. So we also need to cover our issues. So that is also a challenge that we learn from that, how we can still be clear, we can be sufficiently slow, and also complete the issues that I am expected to argue in that particular amount of time. So yes, you should be slow comparatively, and you should be careful in making your submission. Second point, while I open my submissions, I always try to create a connect with the court in those first 10 seconds, where I can use my tone or invite a question or engage with the tone. Because that tone, like I said, I gave you an example of this gentleman who started off on the wrong foot with the court, if I may say so. So engaging with the court is a subtle art. This comes with experience. This comes with constant practice. It comes with discussing your cases with your friends, appreciating their points of views. When you are dense with all these experiences, that is when you will be able to engage with the other person. So the judge who is sitting before you, always remember, engaging with that person. You will have a very little time to befriend. Imagine you have been given 10 minutes to befriend a person so that he rules in your favor. So this is the art. This is the art. This brings me, I'm just cutting off the topic we'll hold here, brings me to a very good example that Mr. Arif Salvi in one of his lectures was discussing, that lawyers are also salesmen. And when he said this, obviously, even now, you'll have sharpened ears of listening as lawyers to be salesmen. But then what he says further is that lawyers are salesmen of ideas. So when a fact comes to me, or when a law needs to be applied to a particular fact, there's an idea. There is an idea that is supposed to be sold to the court. The court is supposed to accept it. The court is supposed to rule in your favor. The court is supposed to empathize with you, probably sympathize with you. But that is the art that a lawyer requires. You, as a salesman, a lot of times we also have an experience that a salesman comes, knocks on your door, and he says, "I don't need it," and the salesman has to leave. So, better salesmen, sometimes you will have experience in your life that you end up buying something that you don't want. Now, that was the skill of that salesman. So he created that need. He persuaded you. He engaged with you in those 10 minutes. And that is how he could sell that product to you. That was the job of the salesman. Similarly, as a lawyer, you have to incept that idea. You have to come to the court with a engagement that in these 10 minutes, you will convince the court, befriend the court, so that the court feels that what you are arguing is the best possible argument that is to be made in the facts and circumstances of the court. So yes, engagement becomes the second thing. Speaking slowly, carefully, and then engaging with the court, inviting a few questions, making the court comfortable with your tone, and being comfortable with understanding the gestures of the court, the way the court is looking at the matter, what is the mood of the court on that day. These are things that, as lawyers, we follow when we practice in the higher courts or even at the lower courts when we have to make an important argument. Now, again, this brings me back to the conclusion that you have to understand that this is an exercise. Communication is an exercise, and etiquettes and mannerisms are a part of it. So you have to constantly keep practicing this exercise, keep reading more about it, keep engaging with people more, keep engaging with your friends, discussing issues with them. This is an exercise that you can do on day-to-day basis to learn mooting better, learn communicating your ideas better, learn accepting difference of ideas. That is also a very important aspect, that you should always be ready to accept and understand, also distinguish the contrary ideas that are put to you. And this comes with practice. You have to n number of times read laws, discuss laws with your friends, discuss your moot court problems with your colleague, with your co-speaker, with your researcher, take their point of view, try to convince them of your argument. So these are the exercises that I used to follow. I used to present my cases with my friends who were kind enough to bear the brunt of my arguments for a number of times. We should just sit at the back benches and listen me argue. I used to also practice my tonal quality, sitting down at the benches and asking my friend to sit right across the hall. Listen, how do I sound without a mic? What my tone persists of. So these are the notes that we used to make always, because that is how we were going to make sure that we are expressing exactly what we want to express. And my tone or my body gestures do not give away something that is contrary for what I want to communicate to the court. And that is why these etiquettes, court mannerisms, observation of the court, uh, being slow when you speak, being careful, being available for the questions put to you by the court. These are the things that you learn when you practice the skill of communication in the field of advocacy or lawyering. Having said that, these are the preparatory materials that every day you have to, if you want to become a successful mooter, or you want to become a bearably good lawyer or an advocate who is going to stand out. These are the exercises that we have to do on a day-to-day basis, whether it is vigilance, being careful of your surroundings, whether learning communication, whether sitting with a person probably who is a novice to law, trying to communicate him in the simplest or the most logical manner, a particular provision of the law. This helps you understand that how basics can be caught in explanations of law. So these are exercises that I recommend that you do on day-to-day basis. It's not a one-day job, and this definitely pays off. Watch a number of videos that are available online where you can also focus on how a particular presenter has presented, how he has taken a question, how he has addressed the court. All these things you will learn when you watch various mooters that are recorded and available online. Now, coming to your presentation, once you appear before the court, as we were taught, I will also put that same set of rules before you. That the first words that come out of your mouth when you present before a dais, whether it is in the real life or as an advocate or as a mooter, the first words that come out of your mouth are, "If it may please this honorable court." That is how you start. This is a standard practice across the country before the Supreme Court or the Bombay High Court that we practice together. This is the standard way that we argue. So, if it may please this honorable court is how we start. Now, this is an etiquette. This is a mannerism that has to be followed before the court. And I would suggest or recommend for you to not just by heart this, but try to understand why a particular language or particular phraseology has been involved in the practice of law or in mooting, why you are taught, why this is taken as an exercise to put you to practice of such phraseology or such a particular mannerism that we need to follow in courts of law. Yes, it may please this honorable court. This is the counsel appearing on behalf of the petitioner or respondent, as your case may be. And counsel will be addressing the court on the following issues in the case of. So this is how we actually set the tone of the court. And why this is set in a particular way? Because we are always expected to be deferential to the court, respectful to the court. That is why in this pattern, we are always expected to be obliged to the court or grateful to the court, as the title of our lecture series is. We are always uh, going to be grateful to the court in a fashion from our words also, in the way we communicate also, and hence this particular phraseology of if it may please this honorable court. This is the counsel appearing on behalf of the petitioner. The counsel will be addressing the court in the case of XYZ versus ABC, and the counsel will be dealing with issues number 1, 2, and 3, and my co-counsel will be dealing with the issues number 4 and 5. So this is how you show deference to the court in a particular phraseology that you use, or if it may please. And note that this is the phrase that usually for asking any permission to the court or citing anything or asking the court to turn to a particular page. Now, if that brings me to a particular example, that if you wish to cite a particular case or you to put court's attention to a particular page or a citation that you have cited or a report or any page number, there's a particular way that you seek indulgence of the court. So in moot courts and even at the higher courts when we practice, this is the language we use. Is somebody's mic on? Some disturbance. Please close your, please shut down your mic. There was some disturbance. Yeah, better. Yes. So after using this phrase that this is the counsel appearing on behalf of the petitioner or the respondent, the respectful submission, my respectful submission, or the counsel respectfully submits that. These are the phrases that you need to tie to your hand whenever you're speaking about or you're submitting to the court. Though it is said that it is an argument being made to the court, always remember that do not use the word that the counsel is arguing. The argument of the counsel is. It is always a submission to the court. Though it is called an argument, but you're not arguing with the court. So always make use of the words that the respectful submission on behalf of the petitioner or the respectful submission on behalf of the respondent. And these are the phrases that you always need to keep in mind. Now, I will share experiences because I have experience of judging a lot of moot court competitions also, the National Moot Court at our college also. Uh, what we see in our practice also and in these moot courts also, that mooters do not have a problem unless and until they are interrupted. So this becomes a good area of concern or practice, that what happens when you're interrupted by the court on a particular question, whether it may be a question of fact or the question of law that the court wants you to address to. So how do you tackle that particular situation? So always understand that I will give you the hack that why this is done by the judges, because we are there to judge you as a mooter. There we are not uh, going to give you a judgment, or it's not a real life scenario. So there we test whether after being interrupted, whether you can hold your argument, whether you can hold the focus of your argument and still complete it. So the idea to interrupt you sometimes is to also seek address to a question, but also to see whether you are focused in your argument, whether you can again consolidate your entire argument and bring it before the court. Sometimes, most of the times, the difference between the teams that win or go ahead in further rounds or the last rounds and the teams which do not qualify is this, that they are not able to first answer the question addressed to them by the court, or sometimes when once they have addressed it, they sometimes forget as to where they had left their argument, and they have a scattered approach thereafter. So they lose their points there also. So the best possible way is that not reading out of your memorial is one of the things. That one etiquette that you have to follow, just do not put down your head and start reading for your memorial. You have to prepare your case in a way where you can present to the court with an eye contact. You have to look at the court. You have to be confident about the facts of the case. You have to address the court. We are not going to present a case in a moot court. It's not a case presentation competition that you look down and read the facts of the case. You have to make eye contact with the judge. You have to communicate, engage with the judge, explain the judge the facts, and then the application of law. So this is what is expected from you. Hence, it is not expected from you to read out of your memorial, because when you do that, it becomes very difficult for you to address a query that is put before by the court. And when you are reading out of the memorial, it becomes very difficult for you to come back to that point and then again address the entire arguments that are left to be addressed by you. So prepare your argument where you have to argue in absence of the memorial. You do not need to read out of the memorial. And when you do this, and when a judge puts a question to you, always remember that you answer in the positive or the negative first. Either say yes or no. Do not start meandering around the issue at all. This is not taken well by the court in real practice also, neither in the moot courts. So do not meander around with the issue. Pinpointedly answer yes or no if that question is capable of being answered in yes or no. Or else you can use the words like indeed, my lord, or indeed, your lordships. Or you can use the word that if I may assist the court. This is how you take the question. Now, one hack that I use, or the trick I use in my arguments, is sometimes you're not able to conceive the question put by the bench. It is always good to repeat the question sometimes. So, if the court has asked me that whether a particular provision applies to this particular fact or not, I would go back to the court and say that whether my lordships want my assistance on the fact that the section so and so of particular act applies to this particular case. This is how you can again bring the momentum back to your argument. So sometimes with some courts, if you read the court well, this is a good way of going ahead and repeating the question so that it gives you some time to think about the question also, and it also does not break the continuity of your argument. So one, that you have to answer the question in yes or no then and there, and you have to also, if you need time to register what the question was, you can also use this technique of repeating the question to the court in a very polite manner, and then ask the court whether this is the exact assistance that the court expects from me or from the counsel so far as this section is concerned. And once the court has delivered on that, you start again with the argument. So this is one of the recommendations that I make, that this is the technique of argument that you can use, and it will not break your continuity, and it will also help you understand the question in those split couple of seconds. And also answer to the point. When a question is put to you, meandering around the question is not expected by any court, whether it is a moot court or in real life. If the answer is available to you direct, you have to directly answer the question and then move on the explanation. And sometimes you will come across that in the present, for whatever reason, in the facts that you have at hand or the brief you hold, the question that is raised by the court is probably not applicable to your case. So it may not be applicable, but then the denial to the court also has to be very humble. So I recommend that always concede to the court, always concede. So sometimes we use the phraseology as a mooter that I concede to this honorable court's view. I admit, always accept the view of the court. So the court, I would not suggest that right or wrong, the court may be right or wrong and accept the view. I suggest that the court is somewhere on a different point. So when you do not agree with the court, it means that the court is on a different point. It does not mean that the court is wrong. So the better way to put it is that you concede to the interpretation, or you concede to the court's observation. However, or if I may suggest a different view in the present case, how may I distinguish that particular view to the facts present before me? So these are some humble ways. So always remember that you accept the court's view. Do not go in a denial immediately. Do not say no, or do not say that this is not applicable. That does not is not perceived well by the courts. So there is a way that you also register your non-acceptance of a particular point, and this is the way you do it. Ask for time to give a counter review. So this is one of the recommendations again. And moving ahead, do not extension of this point. Do not use the word "I think." Do not use the word "I believe." Do not use the words like "I feel." So this is something in informal communication. You have to be extremely formal to the court, right? So these are the words which have to be replaced the phrases of what I have discussed with you. This is the belief of the council, or however, the respectful submission of the council is. This is how you register if you don't agree with the court. If you want to suggest a belief, you may also start with the phrase that the anxiety of the council is this, so you can move on with your issue. So go through it multiple times, watch multiple videos that are available, and yes, this is an art. Communication is an art. It requires practice, practice, and practice. It requires observation. It requires reading the other person, looking in the eyes of the other person, and understanding that whether that person is okay with the explanation that you have granted, or will require any other assistance. In a situation where you're caught, if a similar situation in moot courts, you always ask the court that if you see doubt in the court's demeanor or in the court's eyes, you always ask that if the counsel may assist the court on any point. So this is also a good way of engaging with the court. This is also an etiquette that you can extend to the court. So if there is any persistent anxiety in the court's mind, you can address it then and there. This is one of the points. Secondly, the personal example that I gave, you should learn from that never interrupt the court. Never ever interrupt the court. Whenever the court puts out any query, always remember that you overtoning the judge or you interrupting the judge could stand between you getting that relief on that day. Because the judge who is learned, who has an experience of vast years sitting across you, that person is stuck on a particular singular point. So you have to address that point first. And once that anxiety is relieved from his head, he will be able to listen to your argument further. So if you do not address that query and just keep on arguing, the court's mind will always be stuck on the query that is there in its head. So you may argue 10 pages after that query, but then it would not register to the court. So whenever a court interrupts you, whether a court intervenes with a question, make sure that you address that question then and there, and then politely move on to your argument, or use that communication skill, that engagement skill to invite a question further and an explanation, and then just combine the entire thing in a very polite manner. And I think being differential, like I covered earlier, that you have to be respectful to the court, use of the words that you have to be obliged for any permission granted or any permission sought and granted. You have to make use of the words obliged, highly obliged. You can use the word thankful sometimes, but it is suggested that you use the word obliged regularly. Uh, and always mention in third person, do not speak in first person, do not be informal in any way, practice the language, read more about the phraseology that is used in law. There is no substitute to reading. So I am faced with a lot of questions from young mooters and college friends that how do we develop the language? How do we develop the connecting words? There is no substitute to reading. So as much as you read, it could be literature, it could be good literature, it could be law, it could be commentaries. Keep on reading on that subject, because when you read on that subject a particular amount of time, you start picking the intentful words that are used in that particular area of law or particular area of submission. So there is no substitute to reading. So the important part of the etiquettes and court mannerism also flows down to how well you are read. So if you're well read, then definitely you have substance in your head. And once you have the substance in your head, you will always be careful when you speak. Your demeanor will always be polite, because you understand the density of the subject, you understand the density of the queries. So you will never be anxious. And one important point that I would like to point out over here is that etiquette and court mannerisms, do a lot with your personality as a lawyer. So if you are an aggressive individual, sometimes that is an overtone that you perceive when it goes to the court. So you also have to understand that you have to comprehend your own personality. You have to develop yourself in a particular way. You have to develop yourself as a mooter, as a lawyer in life. You may be very aggressive, but then that tone is not acceptable to the court. And it's only a matter of time that in the moment you may lose control of your speech. So it is not only about practicing, or it is not a role that you're going to play. You have to imbibe that quality implicitly. You have to put it in yourself. So sometimes you have to qualify yourself that what is your personality, what is the type of argument, particularly that suits the tone of your voice. All these things are a matter of practice. These are small nuances, recording yourself, like I already said, and listening to your arguments over and over again, trying it with different tones, keeping yourself aware of the facts around the case. All these things come together to help you understand the etiquettes and court mannerisms all the more better. When it comes to the exact phraseology, I would recommend again that you watch n number of videos, go to the moot court competitions. I think some of the rounds of our moot court competition is also available online for this year. So we have to take an active call, and this is a subject which is so vast, and it is going to come by way of practice and observation. That the more you try to learn, the more you try to engage in this subject, you will learn every single day. And trust me that as a lawyer also, every single day you will have these experiences in life, and these experiences become notable only when you are aware of yourself and you note them down. So if I can discuss a couple of experiences from my practicing so far experience, it is because I was looking at my practice in a particular way. Uh, I I made sure that I was vigilant about the happenings around, and that is how I will develop therefrom. I will not make the same mistake. So if you are not aware, then it is very difficult for you to recognize your mistakes, and that is how you will not develop. So make this constant effort. Your your tone plays a very important role, like I already discussed. The phraseology, by reading, it is going to be imbibed in the way you speak, being careful. And trust me, this will come as an advocate in your life also. You will achieve density. You will not speak at the spur of the moment, because you, as a lawyer, are trained to speak or analyze multiple facets of a particular fact before you put your opinion. So imbibe that in your life. Imbibe that as a student, that whenever you have to present a topic or you want to convince someone, you should be aware and you should be able to express the multiple facets to yourself. And this should happen by way of a habit, that once you perceive a particular point, you should be able to see flip sides of it. You have to see multiple sides of it before you put out an opinion. And once you do this, you will come out with better etiquettes, you will come out with better manners before the court. You will be, law as a subject is so humbling, the practice is so humbling, we see life so closely that it denses you in life all the more together. You don't need to put any extra effort. You just need to concentrate on your practice, concentrate on this entire exercise of moot court. It will make you understand that how little we know when it comes to law, and there is so much to read. So yes, these are the basic points that I wanted to discuss when it came to etiquettes and court mannerisms. So if there are any questions, or if on particular points anybody wants to discuss, I'm more than happy.
Yeah, the forum is now open for the question and answer round. I request you all to kindly type in your questions in the chat box.
With your names also, so that we can hold up the culprit. Okay. So I think they can ask directly if there's no problem, because typing again they will take some time. So
Sure,
there are a
sure,
couple
sure,
of
sir.
questions. If they want to share, they can share directly.
Sure. So I think there are no questions. I think everybody seems to be pretty content with the session. So I think we could move towards a vote
I
of thanks.
either they have listened to everything or if they have not listened to anything at all. So these are the
No,
two
so it was
conclusions. So there are no questions. So that is in the
no,
lighter
so it was
vein.
very informative.
Yes.
Yes, sir. So I'll just proceed towards the vote of thanks now.
Yes.
Firstly, I would like to thank Advocate Anurag Mishra, sir, for his virtuous words, guidance, and informative interaction with all of us. Sir, today's lecture has indeed highlighted on the importance of etiquettes and courtroom mannerisms in the legal profession. Uh, I would further like to express my gratitude to Dr. Sharath Kunte, sir, Chairman of Deccan Education Society, and Advocate Nitin Apte, sir, Chairman of College Development Committee, Sri Navalmal Firodia Law College, for their continuous guidance and support. I would also like to thank our Principal in charge, Nalini Ambad ma'am, for being a constant pillar of support in all our events and activities. I also express my sincere gratitude and thank our faculty coordinators, Dr. Aishwarya Kadam ma'am and Assistant Professor Prajakta Bhagwat ma'am, for helping us make this event a success. I would also like to thank all the faculty members and the administrative staff for their rock solid support and encouragement. Last but not the least, I would like to express my sincere gratitude to all the student volunteers, technical support team, and of course, the audience for making this event such a success. Thank you so much.
Thank you. Thank you, everybody. Please stay safe, be careful in the current times, and keep developing on law. Keep reading. Yes, can we sign off?
Yes,
Yes, sir.
Anurag.
Yes,
Thank you.
yes, yes. Thank you, ma'am. Ganga, ma'am, thank you very much. All the faculty in charge, thank you very much.
Thank you, sir. Thank you. Thank you.
Thank
Yes,
you.
thank you, Anurag.
Thank you.